Hi friends, two jury verdicts from two different states of United States means big tech has just lost its most powerful legal protection. Let's see. Suppose you come across an offensive post on social media, something that deeply hurt your religious sentiments. You were upset and decided to take legal action. But here is the twist. You cannot hold the social media company accountable for what you just saw. You could only file a case against the person who actually posted it. Why so? Because until now, social media companies enjoyed a powerful legal shield under Section 230 of the Communications Decency Act 1996. This rule treated social media companies as intermediaries, not as publishers of user content. Under this shield, platforms were largely protected from being sued for the post their users share. But that is starting to change. Two recent jury verdicts in the United States for the first time announced that social media companies are also potentially accountable. Social media companies from here on will be liable not just for what users post, but also for how their own products are designed in terms of algorithms, feeds, recommendation, and how they handle safety and addiction style harm. This does not mean you can sue a platform for every offensive post you see. Section 230 still largely protects companies from being treated as publishers of user-generated content. But what these verdicts mean is that going forward, companies may be held accountable for the choices they make in designing and operating their platforms, especially when those choices cause real, demonstrable harm. An analogy to help you understand. Think of a food delivery app. The app is an intermediary between you and restaurants. If the food you order from a restaurant makes you sick, you usually sue the restaurant, not the app. For that, the app is protected. But what if the app deliberately promotes only the cheapest, lowest quality restaurants? The app hides health warnings, and the app keeps you scrolling late at night with addictive features, with something like discounts valid for 1 hour only, etc. Then the harm isn't just from the food alone, it is also from how the app is designed and operated. That's the shift the new US verdicts are signaling. Section 230 still protects social media platforms from being treated as publishers of user posts, but it may not protect them from being held accountable for how their own products are built and run when those choices cause real harm. What is Section 230 of the Communications Decency Act 1996? It is a US law protecting online platforms from legal liability for content created by a third-party user. The law also allows the platforms to moderate or remove content in good faith. The key exception and limitation of this law is that it does not protect platforms from grave crimes like money laundering, child sexual abuse content, copyright infringement, and so on. Now, what are those two jury verdicts and which are those social media companies? First verdict, social media addiction case filed in California. A 20-year-old California woman filed a personal injury negligence suit claiming that Instagram and YouTube caused her psychological harm and addiction because of their addictive design and lack of warnings. The case focused on product design liability, that is how the apps work, rather than the specific user posted content. Snapchat and TikTok were originally named, but they settled before the trial. The jury found Meta and Google liable for negligent design and failure to warn, awarding the plaintiff $6 million in total damages. The second verdict, the second case was a child safety consumer protection case in the state of New Mexico. The New Mexico Attorney General filed a civil consumer protection case under New Mexico's Unfair Practices Act. The state of New Mexico accused Meta company of designing its apps in a way that maximized engagement and ad revenue, even though it knew kids were being exposed to predators and harmful sexual content, and the company was not really confronting this particular problem. This was supported by internal company documents and engineer testimony. The jury found Meta liable, concluding it violated the state consumer protection law and engaged in unconscionable practices towards children. Penalties could reach around US dollars 375 to 400 million. The evidences submitted in both the cases reveal that concerns around compulsive use and harm to younger users were known within companies, even as viewer engagement remained the prime motive for these companies. The platforms were built so as to maximize the viewer engagement. In other words, even though they knew the risk, the social media companies did not change their core design. What all these mean is that young users becoming addictive to such platforms is not just by accident. It is because these platforms were built that way. Such bitter truth findings are moving different countries into making laws to ban social media for children. Countries like Australia, France, Denmark, Spain, and Malaysia have already passed laws restricting social media access for children, and many others across Europe and Asia are actively planning. But how effective are these social media bans? Users will almost always find a way to get around age-based restrictions like faking their age, using fake documents, or sharing accounts. There are other addictive platforms which may not particularly fall under the social media category. What is a social media exactly? Are governments trying to ban the platform themselves or the algorithm and design features that keep the children addicted? Many other digital avenues like online games, chatbots, streaming apps, and messaging platforms may not technically be called social media, but they are still addictive. Such products often use same addictive mechanics like endless feeds, rewards, and push notifications, yet they fall outside many current social media ban laws. The solution, therefore, must not try to blanket ban everything social. Instead, they must focus on the design architecture of such platforms. There should be limits to autoplay and endless scroll, and greater transparency around the recommendation systems, and so on. In summary, the two landmark verdicts have opened the gate for the social media companies to reform themselves rather than exploiting users' psychology. Before we wind up, do you think these verdicts are applicable only in the US or all around the world? Let us know in the comments. Thank you.